Hello everyone. Hello. So firstly, congratulations for moving on to the last stage. So I think in the later end of the evening, you will be fighting for winning this entire competition. So firstly, all the best to each and everyone. And thanks to IIT Madras for creating this session, because I sometimes feel that yes, anybody who is starting a unique startup or anybody who is coming up with a unique idea, people are so much concentrated upon that idea that they sometimes end up putting the legal orbit on the backside. And at a later point of time, they realize, okay, this is something important, something very relevant when they are starting a business, and they need to take care of to prevent any irrelevant headache or something. So hence, today I'm going to brief a bit about what is Vakil Search about, how Vakil Search helps per se. Then I'm going to talk about different kind of legal aspects, like what are the right company to incorporate, what are the legal documentation, and what are the different IPs to protect per se, because that is one of my cores also. So before I go into this, into detailing about the different aspects. So again, out of all the people, I think we have 12 teams here, yes. Correct? So how many have already registered their companies? Oh, everybody has registered their companies. So how many are like 3-year-old companies? Okay, how many are 2-year-old companies? One. This is entire one team. Okay, 1, 2, 3. Okay, perfect. So we have big people. And how many of you have already applied for a trademark or a copyright or a patent? 1, 2, 3, 4. Almost everyone, barring 1 or 2. Okay. So again, most of the people, again, I would say people are already aware on the different aspects. But again, I will delve into deep. And again, I will try to wrap it up as soon so that you can ask me questions or clarify any queries. Vakil Search was initially started around a decade back with the whole concept of making law accessible. Because in India, the lawyers, CAs, CS, they are not, to make it easily reachable to you at home while sitting and making a call. That was the whole concept that it was made. And to make it cost effective. Whenever anybody sees, okay, you have to go get a CA, they will charge me lakhs and lakhs of rupees, or I have to reach out to a lawyer, they will take me for a ride and take lakhs or something out of it. So that was the reason this was created, to make it transparent for anybody, so that you can reach, you can check whatever, you can have a read, you can do your own research, and then take the final call. So again, over the years, again, we have been able to cater to at least, again, more than 5 lakh clients. As of date, we are incorporating at least 10% of the companies in India, and have drafted again 80,000 plus documents, done 20 plus compliances of companies. With respect to IP, we have done almost 1 lakh trademarks. With respect to patents, which people like, again, like you or different industries, we have already done around 300 plus patents, even more, yeah, 300 plus patents, and many designs also. So basic aspect is, whenever you are starting, there are few aspects that you need to take care of. Firstly is business registration. So, okay, again, I will do the raise hand thing for everyone. So how many of you have incorporated a private limited company? Okay, everybody has incorporated a private limited company itself. Okay, anybody who has done LLP? LLP, okay, 1-person company? Sorry? Private limited itself, perfect. Anybody who is still a sole proprietorship, who has not registered as a private limited? None, okay, so great. So again, because usually people have, whenever I have a discussion with startups who are, anybody who has still not launched anything? Everybody has launched their product and have incorporated. Okay, 1, 2, 3, 4, 5. Prototypes, in the prototype stage. Okay, so for the people who are right now still at the initial stage, normally question that I end up getting is, sir, okay, we have to start a business. There are so many kind of varieties of companies. One is a sole proprietorship, one is a OPC, then there is an LLP, then there is a private limited company. What to do? That's a major confusion, major doubts that people come in mind. And to all the people, many people who say, sir, I don't want to get into that compliance, so many compliances are required to be done. I will start a sole proprietorship. So should we do that sole proprietorship company, or should we get into a normal partnership deed, get into an agreement and get it signed? So normally it is not something people find it easy, but if you're looking at a long-term goal, if you're looking, okay, nahin, I have to scale my business right now from here till here, and I have to make crores out of it, and I have to create a proper business around it, it's not suggested. It is always suggested to go for a private limited company itself, or in few cases an LLP. So again, the basic benefits again is any company who is looking to invest into you, or you are looking for any investors or any person who is ready to fund you, they would be always looking for a company who is in the structure of a private limited, because they would be wanting shareholding, as simple as that. Everybody, they would be wanting some kind of shareholding in that. So always, whenever starting, try to make it a private limited company, which majority of you have already done. For the LLP is sometimes suggested because of the tax benefits. So there are various kind of tax benefits that a structuring of an LLP provides. So that is a second best option if you want to go ahead with. Okay, if you don't want, obviously there are too many compliances that have to be done in a private limited company, indeed. But again, that is simply to keep a proper track and to make sure that everything is plain black and white. LLP is a bit less in compliances, yes, but yes, it has many taxation benefits that you might get over the period of time. Okay, but still, on a personal level, I still always suggest that go for private limited company, because considering the Ministry of Corporate Affairs, how they are working, registering a private limited is much faster than an LP as of date. Because LLP is taking right now around 5 to 6 months also sometimes to even register, because again, because of some major issues, I'm hoping in next 6 to 8 months or 1 year something they will resolve it. But private limited, they are doing it within a month or something. So, but yes, the rough idea again, what to start, what to incorporate, this is the basic pointer. With respect to one-person company, you can incorporate that if there is only one person heading and doing everything. But yes, you will still need a nominee kind of nominee director, starting a one-person company. And if somebody is simply testing out things, not going to launch, or simply doing testing with friends and colleagues, yes, you can do that as a sole proprietorship or whatever, to be on still legally. But yes, for testing phase, you can do it in that manner. Okay. Okay. So this is, whenever you talk about compliances, India is one of those countries which has filled itself with too many compliances and regulations that have to be complied. In India, overall, there are around 50,000 different kind of licenses and registrations and compliances any business has to do. And each business per se have to comply with around 20 to 25 different compliances. And I can tell people here, everybody might have applied for a company registration, they would have applied for a GST, and then they would have applied for a trademark. Except these three, very few people might have known okay, what are the other 10 or 15 other things or the compliances that they need to do. And that's where they fall short sometime a bit. Because these are the things that have been popularized by lawyers or other people that have been made aware. Thanks to Amazon, people know about trademark also now. It has become compulsion to apply. But again, there are various compliances that any business have to start when they're starting a business. So again, basically, for example, labor compliances. So again, there's something called as POSH compliance. How many of you are doing POSH compliances? Nobody is doing POSH compliance. It's a basic compliance that is a compulsion if you have a 10-person company and you have a single lady employee in the company. It's a compulsory compliance to be done. Otherwise, you will have an annual penalty upon you of 50,000. It's a small amount, but which will keep on getting compounded. So similarly, again, this is POSH. Again, if you are in the food industry, then there is FSI license registration that you need. Many people would be knowing FSI, so it's a bit of a common. But like this, again, even as a lawyer, I have been in this industry for a few years, but I won't remember 50,000 licenses. Nobody can remember 50,000 licenses. So point is, whenever you are starting off a business, this is one industry-specific license, compliances that you have to do. Every industry has 1 or 2 or 3 or 4 compliances. Like few of the compliances, as I said, if you're in the liquor business, you need liquor license. If you're in the food business, you need FSI license. If you are into a manufacturing business of some steel products, there's some specific state-specific manufacturing licenses are there that is required. So the point is, every industry will have 5 to 6 or 7 industry-specific licenses that you need. The point is, that is an additional point Even when you're pitching, anybody, when you are pitching to anybody, your strength in your compliance reflects upon you. Ki, okay, I am legally strong. I have clarified all. I am not going to face any kind of legal hurdle 1 year or 2 years down the lane. This is how my strength is. I'm going to talk about how IP is helpful at the time for pitching also. But right now, legally, so that you don't end up into tussles or issues, right now we keep on getting, ki, sir, okay, I have registered my company, I have been running for 5 years, and I have never done a, let's take posh compliance only. And now they have got 4 to 5 notices compounding through 4 to 5 lakhs or 10 lakhs. So now they say, sir, this is a huge amount, what to do about it? So you should have paid few thousand bucks, completed, and you could not have got. The point is, people get into this, you get sealed, you get government notice, and you get into stupid, I would say, hurdles or irrelevant tension. You guys are all entrepreneurs, inventors, creators. You guys should be working upon ideas. That's the task for a lawyer or a C or CS, to take care of these all respective tasks. But yes, it is important that you pay equal attention to it so that you don't face these hurdles, you don't face these problems whenever you are starting. Okay. Documentation. Okay, so this is, I would say, one of the most important, considering everybody is working here in teams. Whenever you are starting any business, and considering you are starting with 1, 2, or 3 friends, you might be friends, you might be colleagues, you might be relatives or something, or in all cases, there is a very basic importance of contracts, agreements. No matter how chuddy-buddy person you are, how well-known you know that person, or how well-known that family member might be, he might be a sister to you or a brother to you, always have a very clear-cut agreement structured with whomever you are working, irrespective of how long you have known. I have seen people who have been friends for around 30 years, and at the end they end up into having a dispute and not having a proper documentation, and now they are spending lakhs and lakhs in court fighting the case as to the right over the company and the shareholding of the same. So there is no harm, there is no, have a very clear-cut document always created with your colleagues whom you are working, with your partners, co-founders, investors that you are working. Cross-check those agreements 10 times, 20 times, ask question. Never hesitate, because this is the future of your company. If you're signing any agreement with any of your colleagues, or you are bringing on board any person who is bringing in some products and is saying, I want 1% or 5% or whatever, always go through. Have a proper due diligence of any agreement that you ever sign with anyone. Not only that, if you are signing, but the point is, considering you are a 3-person, for example, you 3 are founders, you are working along with each other, and you have a team of 20 people, out of which 10 are employees, 2 are accountants, 2 are vendors, 3 are warehouses, 2 are marketing persons, marketing agency, 1 is logo designer. You need to have an agreement with each of the persons that you are working with. No matter what task they are doing, no matter what task, the time of doing it on call, understanding, yes sir, we understand you, that has gone. People back out, they do not complete the task on time, and that have effect upon the business. You get delayed if a warehouse is not ready to stock your products, perishable products. So all those things have an effect upon your business. So make sure, if you are working with 10 people, 50 people, 100 people, you have a signed document or an agreement with each and every one of those people. Then again, employment agreement, I think I have already said, business is fine. Policies, again, everybody, majority of the people would be having some kind of a website or a mobile application about their service, about their product, correct? Everyone. So again, whenever there is a, many people say they develop their website, and then there is, everybody would have seen terms and conditions, refund policy, service policy, shipping policy, and then they tell their website developer, sir, you only put it. I don't need anything, you only put it, what is best according to you. That is the biggest mistake. Because these policies are ones that need to be drafted by a lawyer, which is industry specific, which differs basing which state you are in, which differs which industry that you are catering in, it differs what kind of customers that you are catering to. You are catering to only Indian customers, you are catering to international customers. There are different data privacy laws that have to be complied. If you are catering to international customers, there is GDPR compliances that have to be mentioned. GDPR policies have to be there. People simply get it done and then they come later on, there is some data privacy breach or something, and then they realize, oh, this was something that I missed. So make sure all the policies that you mention in the bottom of your website or somewhere on the top corner or something, those are important. You might not use it, they might not be adding to revenue, but they will save you from irrelevant expenses during the tenure of your business. Okay? And yes, HR policies, these are all compulsory to have it. You should not just have an employment agreement and signed. That is one aspect. If you are working with any of you, you have a team. How many of you have a team of 5 or 6 people? Or 10 people? No one. Right now everybody, okay. Okay. So considering in the future, if you're going to create a team, make sure to have a proper few of the policies like code of conduct, holiday policy, leave and attendance policy, and what else? The POSH policy is also part of this only. So there is a set of 5 to 6 policies that everybody has to create. It's not just create for the sake of, okay, you have to do it, because if you don't do it, again there is a penalty under Shops and Establishment Act. So these are all the people you see, or in your offices, people might have seen there is a proper register and all this is required because they are doing it, because that is legally required to be done. If they don't do it, then that is penalizable upon those companies. So if you are starting, if you have a company, irrespective of the number of employees, if you have 1 or 2 employees also, you have to have this HR policies aspect very clearly mentioned and signed by all the employees. Okay. Coming to IP. So IP is intellectual property. It is simply, IP is what protects your idea. Each and every person, you are sitting here because you have come up with something fantabulous idea, which IIT Madras and the people from the Boeing loved it. And the whole aspect is, whenever you come up with a unique idea, you need to make sure you protect it. You need to make sure that you are the only person making that product in the entire industry. So it should not be a scenario that you come up with something, a unique brand name or a unique invention or a unique design, and the next 5 days or 10 days down the lane, somebody might have taken it up, copied it. Now your entire idea is unique. Nobody will be willing to invest in you because there are 100 people who are already doing it. Your idea is already leaked in the market. So that entire purpose of creating that unique idea, which you might have spent years and years researching upon, is useless. So that's where IP comes into being, which makes sure that your idea, that your invention remains protected, remains yours, so that you can make a complete dominance. Okay, this idea for the next 10, 20, 30 years is going to be mine. This patent for the next 20 years is going to be mine, and you don't have to worry, nobody else can come up with. We can take action against them because I have a patent. I have come up with a unique brand name which is fantabulously different from the market, and nobody from the entirety of the company can use it. So that's where IP comes. If you have a unique design of something, apply for the design registration of the same. For the next 15 years, nobody can copy that design. So that's where it simply gives you an dominance, or it separates you out. It simply separates you out from other 100 people who might be in the similar business or in a similar industry. That's why IP protection is crazily important as of now. Okay, these numbers I think I have already told. So with respect to trademarks, again, many people, okay, they have come up with a name or the logo, they apply for that aspect. Considering whenever you're starting your business, it is always suggested to have, whenever you're applying for a brand name, it is suggested to have 2 to 3 aspects in your brand name. Firstly, yes, you need to have a nice logo. It catches people's eyes. It catches people's eyes simply. So you have a unique logo whenever you are coming. Just don't come up with a simple brand name. If you have a logo, that helps. Second, yes, come up with a name. Name as in, the most common problem that I see is people come up with generic brand name. For like halal chicken, that is what the brand name that they might have come. Or fast speed airlines, for example. These are very generic. You cannot say that they are very unique brand names. Come up with something which has no meaning, no dictionary meaning. Come up with something which has no relation to that goods and services. It's like you cannot apply for the brand name Apple for selling of an apple fruit. They use the Apple for selling of laptops and mobile phones which has zero relation to it. but many people end up using a very similar brand name with respect to the same business that they are doing. Don't do that mistake. You will have issues not only with the trademark department in approving those trademarks, but even there might be some other disputes that you might get or enter into from different kind of vendors. So always and always come up with something fantabulous or a new brand name which is unique, which is a non-dictionary word, which people can remember. And also don't come up with long names. People have a very bad retention power. They usually remember 3, 4, 5, 6 alphabets, nothing more than that. Sorry, just give me a second. Okay. So yeah, and third aspect is slogan. Obviously, if you have a slogan, that is something catchy and will always help you out. So these two major aspects always try to remember and keep in your mind when applying for a trademark. Copyright. Okay. Okay, I will ask again another question with the hands up. Okay, how many of you have a software-based product? 1, 2, 3. Okay, software. So again, so major copyright, again, I will come why I asked this question. Copyright is something, if you have anything, any unique content or any original content that you are writing, which can be in a way of books, paintings, sculptures, films, computer programs, database, technical drawings, all this. If you're writing any kind of unique content, you can apply for the copyright for the same. The biggest plus point of copyright is you don't have to worry about renewal. It is for the eternity of your life. Secondly, even after you die for at least 50, 60 years, after that also it is valid. That is one aspect. But the most common problem that I keep on seeing is people coming, sir, I have come up with a unique software-based product and I want to protect it. And how should I protect it? Because should I patent it? Should I copyright it? Should I design it? How design protect it? What should I do? So again, all computer programs which have a unique coding, they come under copyright protection. As simple. Anything which has a unique coding, they come under a copyright protection. However, if you have a software which works along with the hardware, whatever smallest hardware is that. If a software is running a hardware and the entire process is something unique, something that has not been developed, you can apply for the patent for the same. Normally, a simple software with no hardware involved, you can only apply for the copyright for it. But if you have anything of hardware, you can apply a patent for that. There is another few instances where you can apply for only a software also as a patent, but that is a very fine line, which even I say, okay, I want to see the product and only then I can confirm. So again, if your software is such a way that it enhances the overall working of a hardware, it is not making the hardware work, but it is enhancing the working of a hardware. So for example, cam scanner. Everybody would have used a cam scanner. It's simply, nobody could have thought that you can start scanning the documents through a mobile phone. It overall added a new feature to mobile application, to mobile phone. That's what it added. It made it a scanning machine also. So if you have a software like that which overall enhances the way of working of a hardware, you can patent that also. Okay. So, okay, this is fine. Patent, again, I have already briefed it. But again, whenever you are applying, okay, has anybody applied for a patent till now? 1, 2, 3. Can you mind telling? 4. Can you mind telling what is your patent about? And tell it only if it is published. Secret. Okay. And all are medical devices. Brilliant. In India itself? Okay. Okay. All are granted? 2 are granted, 16 are pending. Okay. Sir? Okay, ocean energy converter. Okay. Applied? Provisional patent you have right now applied. Okay. Okay. Yes. Once you apply, as soon you get a receipt around it. But you have to apply, if you have applied for a provisional patent, within 12 months you have to apply for a complete specification patent also to make sure that it proceeds. But great. That is where a patent comes into, I would be coming on that also. Provisional patent, I think that is what you have applied. So, okay. See, whenever you are applying for a patent, you have to make sure the other people who have not applied or the people who are applying, there are three aspects that you have to make sure. It is new, inventive, industrially applicable. Industrial applicable, everybody understand that it is something you can sell, you can make business out of it. Second aspect, it should be inventive. It should not be something obvious. A discovery of something that cannot be patented. Something which is already existing but you just found it out, that cannot be patented. Something which knows purposely, yeah, this can be done out of this also, that cannot be patented. It should be something which is inventive. Third aspect is it should be new. It should be new as in it should not have been made public. The most common mistakes that I normally see people doing it, they come up with a unique product and they publish it, they talk about it and everything, and they have not applied for the patent for it. So point is, once your invention or once your product, once the unique working of your product is out in the market, it's very hard to get a patent of the same. So before you launch it, before you make it public, always make sure to apply for the patent before, so that any disputes, if anybody does not end up copying it, anybody cannot end up using it. So even like there are two kinds of patents. The one is called provisional patent, one is called complete specification patent. Provisional patent is when your idea is half done, but you want to make sure your idea is protected. Then you apply for a provisional. You apply for the provisional to the fact that patent office themselves do not release that information on their website. They say, okay, this is a unique idea, you want to protect it, complete it first, and then we will publish it. So right now, even the patent office, for example, you have applied, they would not have published that information on their own website. They will keep it hidden until you file a complete. That is applicable for all. So make sure whatever product that you have come up with, apply for the patent at a very fast pace, because if your idea is good, it doesn't take much time to leak out. Okay? So again, be it a unique process or a machine or an article or any unique chemical composition that you have created, or a unique process which is achieving a unique result, even a unique process. So whenever you can basically categorize patent into 2 to 3 aspects. One is a product patent, one is a software patent, third is a process patent. Take care. Product patent, anything, machine, article, that gets covered over there. Second is process. If you have a unique process of achieving something, if you are doing a way of, you are creating a process flow which is something unique and not something which is already existing in the market, you can apply for that as a process patent, simply. Third aspect is software patent. As I have already discussed about software patent, if you have a software which is overall changing how a hardware works, or it is working along with the hardware, you apply for a software patent. These are the basic 3 categories of patents which you need to apply. Yes, if you have a patent in your invention of your product and you're going for any pitch, that is a very added advantage, because your people who will be reviewing, it will be working as an additional feature to showcase for the next 20 years. Patent is valid for 20 years. So for next 20 years, even the people who are going to invest in you, they know, okay, this is an invention, nobody else can comply. You use it or copy it, and if somebody tries it, you can take action against them. So that is an additional aspect. So that is you can use. Okay, and I'm not going to go into details of the patent. Design. Design is simply, again, shape. Whatever tangible product that you have, the shape of that bottle that you're seeing in front of you, or the specs that you are wearing, or the watch that you are wearing, anything which is tangible, if that has a unique shape, that has any shape which you have designed, you have not copied it from somewhere, you can apply for the design registration for the same. If you have any kind of tangible product and that hasn't been designed, again I'm repeating, that can be design protected. I've seen people from designing the tablets that you eat as medicines, those tablets, to the Good Day biscuit that is there, to the unique shape of the noodles that is there, to a shape of a car, to the shape of the mobile phone, to the shape of a bus stand that has been created. All those can be design protected if you have a unique design. The major aspect is, should be new or novel. You should not As I said, it should not be something which you have already launched in the market. Again, patent and design have this one major principle: it should not be made public. So once it is in public, once it is in knowledge for everyone, then you cannot apply for the patent and design. Then in that case, the only way around left is make minor modifications, make some changes in the designing, make changes in the designing to some extent, and then apply for the design or for the patent. That is the only way around then. Okay. Again, this is the basic timeline again. I'm not sure, I have some time, okay. The basic timeline for, again, trademark, you have to renew your trademark every 10 years. Design is like for 15 years, patent is for 20 years, copyright is for like eternity. Okay. And every aspect, the most, again, IP valuation, how many have done an IP valuation of their business? Anybody? You have done an IP valuation. Brilliant. Anybody else? Okay. So IP valuation is very important again. It helps you to value, again, when you are pitching somewhere, it always helps you to show that I have protected my IP to that level. You do a basic analysis. This is the market trend of this specific industry. This is the market trend of this specific invention or the product. This is the growth that we are projecting in 1 year. This is the brand that I have protected, and this is how it is going to grow. And you can say, because I have protected my IP for next 20 years, my valuation for my IP and for in this growth will be this much. And that is how you have protected, this is how you have created a valuation, by simply protecting your IP on right time. So make sure, if you have not done, and if you are going on more such sessions and going for such kind of fundings, obviously you should get an IP valuation done. Business valuation, I think everybody would be doing it, and financial projections and everything. But IP valuation is something that adds on to showcase that you are ready, you are much more ready for that aspect. Okay? And I've already mentioned on the agreements, make sure your agreements are very clear, crisp, and on the point. They should have IP clauses. Majority of the pointers, people do not have a very clear-cut agreement on the IP with the vendors or the manufacturers. I have seen. They have got one manufacturer for manufacturing one of the product. So I've got one client few days back, not few days, a month back or something, who was making the stands, that you see in the marriage halls. But he's the ones who make those on which the food is displayed. But he used to make those stands and everything, but for celebrities. So each stand is unique, and once he makes the stand, he doesn't put it on any other stand then. It gets pushed out. But the point is, his stands were so unique. The fact is, his designers, the people who were designing those designs, they used to design it for him, and then they used to sell those designs or make those designs to somebody else. And those people used to make a very high valued designs, and they were able to make the same design for 20 other people at half a cost. So now, again, the design which was supposed to be one-time use and exclusive, now that design has again got leaked because he did not have a proper agreement with the people who were manufacturing. They were simply laborers, some laborer he outsourced, and he did not have a proper agreement. So make sure, even if you are outsourcing any aspect or manufacturing of even pieces of your product, make sure to have a proper agreement around with the same. Okay, enforcement. So again, till right now I have discussed about applying of the IP, applying of trademark, copyright, patent and design. Most important aspect is having a proper enforcement. Enforcement as in you have applied it, but now if somebody copies it, now when you have to make sure nobody copies it, or take action if somebody has copied it. So that's where enforcement comes in. Again, enforcement differs from instances from time to time. Depending upon a copyright, it will have a criminal proceeding. If a trademark, there is a civil and a difficult criminal proceedings. If patent, then there is a civil proceedings. What are the jurisdictions where you can file? Again, because I'm not thinking of going into details, but the whole point is there are different ways that you can enforce. You can file a FIR also if somebody has copied your copyrighted work. You can file a case in district court and even in high court if somebody has copied your trademark or copyright or patent. You can even go in high court, district and high court. You can both go over there. Both have original jurisdiction to take the case. Initially, again, for handling all these trademark, design, copyright, patent, there is a different department, that is Controller General of patent design and trademarks. So again, there's a first level wherein you can file or challenge if anybody has applied for a similar kind of a copyright, design or patent and trademark, you can challenge it over there. So if somebody has come up with a similar trademark, so that is called something as trademark opposition. Then something called as copyright cancellation proceedings. So patent pre-grant and post-grant opposition, all those things are there. So if you have to file an oppositions. But the point is, major aspect starts then when your IP is registered. You have to make sure it remains yours. So you have to take some steps. So again, if you come across any instances, keep on checking online or on Google. If somebody is applying, get in touch with your IP lawyer, yes, I want to remove it. It's not about simply protecting, it's about saving your own market. There will be competitors or there will be other people who might know that Mr. Rajesh had come up with something fantabulous and and we can just replicate it from his brand is, for example, Nova, and let's create it Novi and we will start a similar product. So you have to be vigilant, because once he comes around, he will take away your clients. He will create a confusion in your clients. The clients who even liked your products, now they will confuse because there is another entity who has a similar product. Now your entire market starts getting diluted. So enforcement is something you should always have. You should always keep a minor amount of a budget in yours. How to make sure my IP stays mine. Annually you should budget something. Okay, if anybody does, I can take action. I have the capability, I have my monetary funds accordingly allocated to handle those instances. And I think that is it. So again, the whole point, the whole aspect of this discussion is to conclude, whenever you are starting off a business, there are few legal aspects, there are many legal aspects, be it compliance related, be it incorporation related, that you have to comply to prevent irrelevant kind of penalties. I have got a list of 10 clients who have missed ROC compliances and they have got 10 lakh of penalty upon them, and now they're saying, sir, close my company altogether, sir. I don't want to pay that penalty, I will start a new company or something, or I will see it and I will try to fight it out or something, I will see it over there. The point is, you need to have a very clear compliance and checks and balances ki haan bhai aapka law is clear. Because that should not be a hurdle for running your business, running your idea and your business. So make sure all those are clear. I think your details are here. If you want, you can click a screenshot of it and keep it with you. And again, if any questions anybody has, after this we can have a discussion on that. Thank you.